I would like to call this meeting to order and welcome everyone that's viewing online or participating through phone and video. Welcome to the Assembly Committee on Legislative Operations and Elections. I would also like to ask our committee secretary to please take roll.
Assemblywoman Dickman.
Here.
Assemblyman Frierson.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Housekeeping.
Here.
Assemblyman Levitt. Assemblyman Matthews.
Here.
Assemblyman MacArthur.
Here.
Assemblywoman Monroe Moreno. Assemblywoman Thomas.
Here.
Assemblywoman Torres.
Here.
Chair Miller.
Here. And will you please mark Assemblywoman Monroe Moreno and Assemblyman Levitt present when they arrive? With that, I will move on to our next agenda item, which is just a few housekeeping tips. Again, if you wish to testify, you can pre-register online through the agenda once the agendas are posted on the Nevada Legislature's website. Upon successful registration, you will receive a telephone number, meeting ID, and instructions for joining the meeting. We do ask that everyone registers individually so we have an accurate count of the number as well as who is testifying and in which position. Also, when you do testify, please unmute and make sure that you state your name, your first and last name clearly for the record. Just a reminder that committee members will be managing a few different types of technology as we're participating in the meeting. So please don't take it as a distraction. It's actually just managing all the different documents and bills in front of us. With that, of course, a reminder for everyone to please turn down the volume on your phones as to not be a distraction if it rings during the meeting. We will take 30 minutes of public comment at the end of the meeting, to which we ask that everyone participating in public comment limit their remarks to 2 minutes per person. With that, again, just a reminder to please turn off your volumes. And we can move on to our next agenda item, which is we have 2 bills on the agenda today. So I would like to open the hearing for the first bill, which is Assembly Bill 65. This is on behalf of the Commission on Ethics, and it makes various changes relating to the provisions governing ethics and providing penalties. With us today, I'd like to introduce Chair Kim Wallen, Vice Chair Brian Dufferin, and Commission Counsel Tracy Chase. And with that, please proceed when you are ready.
Right. Good afternoon, Madam Chair and members of the committee. For the record, I am Kim Wallen, Chair of the Nevada State Commission on Ethics. With citizens having less and less trust in government, now more than ever, we need to place a greater emphasis on ethics to help restore the public's trust in government. AB 65 will help to do that by improving the protection of whistleblowers, which is very important right now. And in fact, just the other day, I was taking an ethics class for my CPA license, and there was a statistics they quoted, and they were saying that the certified fraud examiners were seeing an uptick in fraud and wrongdoing of 11% just from May to November alone. And they said it's only going to get worse. This bill will also improve the due processes for those who have had an ethics complaint filed against them, and it will also streamline some of our processes so that we can operate more efficiently. I want to thank you for your consideration of our bill, and now I will have Commission Counsel Tracy Chase take you through the bill. Thank you.
For the record, this is Tracy Chase, Commission Counsel for the Nevada Commission on Ethics. I'm going to be sharing my screen, so I'm going to take a moment to do that. Thank you for your patience. Can you see the video and the PowerPoint?
Yes, we
Thank
can.
you. Thank you. Again, for the record, my name is Tracy Chase and I'm Commission Counsel for the Nevada Commission on Ethics. The Commission has requested that I go over the primary provisions of Assembly Bill 65 and how it revises the Nevada ethics and government law. The basic purpose of the Nevada ethics in government law is to assure that public officers and public employees maintain proper separation between their personal conflicts and the public duties in order to protect the public's trust in its government. AB 65 improves the Commission's processes. It increases opportunities to obtain education on the ethics law by public officers and public employees. It enhances transparency, has increased due process, and it clarifies certain provisions of our ethical code of standards. It also has some streamlining of certain administrative matters. I want to note for the record at this point in time that Senate Bill 129, considered by this committee in the 2019 legislative session, in part applies to 65. A lot of the provisions in Assembly Bill were taken all the way through till the final day of the session, and the session was so busy it just didn't make it to a final vote. So there's a lot of legislative history in those records. One of the important missions of the Commission is to educate and provide advice to public officers and public employees. They do this through the advisory opinion process. AB 65 streamlines the advisory opinion process. Currently, if a public officer or public employee requests advice on their own conduct, the process starts and it goes before the full Commission to render an opinion. The statute requires that that process be completed within 45 days unless there's a waiver by the requester. The bill actually allows the executive director and commission counsel to provide informal advice. This is especially important when public officers and public employees have a last-minute conflict that arises and they're trying to figure out how to comply with the ethics law and perform their public duties. Now, the advice from the executive director and commission counsel has to be consistent with commission precedent, and it's subject to review by the commission as well. The goal of this is to provide an immediate resource to public officers and public employees. And if they seek that resource and obtain the preventative advice, safe harbor protections are afforded them from a willful or from a violation of the ethics law. In addition, on advisory opinion proceedings, they are currently confidential from the filing from the requester all the way through judicial review, unless the requester waives that confidentiality. AB 65 confirms that informal advice I just mentioned would also be confidential. And the bill also addresses an inconsistency that's currently in place between the ethics law and the open meeting law. Judicial review under the ethics law is to be held in closed session before the courts, unless, of course, there is a waiver by the requester. And the open meeting law has a provision that the commission to respond to litigation has to go into a public meeting to designate litigation direction. The inconsistency is that we're required to maintain the confidentiality of on advisory opinions. So therefore, the commission is requesting an exemption from the open meeting law. Again, if the requester waives confidentiality, the bill provides how a public hearing will be held by the commission to consider the advisory opinion request. Some other advisory opinion process revisions that the bill does is the commission, once the request is filed with it, it may need additional information to complete its opinion relating to that request. And now they may request additional information, and the 45-day timeline that's statutorily required to process the written opinion is told or basically extended for the period of time until that supplemental information is received. the bill permits good cause extensions of time. Now, you will see throughout this slideshow that good cause extensions of time are going to be provided at every level of proceedings of the commission, whether it be an advisory opinion or if it's in the ethics complaint matters. And the reason for this is the COVID-19 pandemic has really shown the commission the need for flexibility to grant good cause extensions in matters. The bill also allows for a stay by the commission of an advisory opinion request if it receives an ethics complaint that has the same or similar matters that are being requested. It authorizes the commission to determine which written opinions would constitute binding advice, and it clarifies when a local ethics committee may refer questions to the commission. Assembly Bill 65 also improves the complaint processes before the commission. A member of the public may file a complaint with the commission alleging that a public officer or a public employee has violated the ethics law. That complaint has a process it goes through to the commission. In general, it has a jurisdictional review process, and then if it proceeds to an investigation, it has an investigation process that is concluded by a 3-member panel, and that panel can refer the complaint to the commission for additional proceedings, or it has authority to dismiss or try to resolve the complaint at that phase of proceedings. Assembly Bill 65 has some improvements to the complaint process. Again, in every phase of proceedings, the commission is requesting the ability to grant good cause extension. In addition, when a public officer or public employee that is employed at the same agency as the subject of the complaint files a complaint and requests confidentiality, they're afforded currently confidentiality protections under the ethics law. This is the whistleblower protection that the chair of the commission was referencing. The process improvements also are due process improvements, and public officers, employees are now required to cooperate in investigations unless they have legal protections otherwise. Talking about the whistleblower, the confidentiality protections for complainants. Confidentiality protections, as I indicated, are for those who are employed by the same agency, or if a person can demonstrate that there is a viable threat of physical harm. AB 65 provisions extend the confidentiality protections to the materials that the complainant files. When a requester for a complaint files the materials, he or she is required to back up that complaint with evidence that there has been a violation of the ethics law. That evidence oftentimes will demonstrate who the filer of the complaint is. Perhaps there's a handwritten note, or it's such a small agency that if the requester is granted confidentiality by reason of being in the same agency, oftentimes the subject can narrow the field of who filed that complaint or try to guess who filed the complaint. So what the commission is requesting, and you'll see this throughout all the different phases of the complaint process, is basically a notice process. And I'll explain what that is in a few slides. Also, if the complainant is a witness in the adjudicatory hearing before the commission, certain precautions are established to continue to protect their identity as the filer of that complaint. If the complaint goes past the jurisdictional acceptance phase and the commission directs an investigation, the executive director of the commission is charged with completing that investigation within 70 days. And again, instead of the complaint being provided to the subject, because the subject is already provided the opportunity to provide us a response to the complaint, a notice of investigation will replace the copy of the complaint. This ensures confidentiality protections of the filers who are entitled to them under the ethics law. In addition, some other improvements to the investigative stage of proceedings would be investigative subpoenas, and again, the good cause extensions of time at this phase of the ethics complaint as well. Once the commission completes her, once the executive director completes her investigation, She is to provide a recommendation to a three-member review panel of the commission on whether or not there is sufficient evidence for that complaint to be referred to the commission for a hearing on the complaint. The review panel process improvements are twofold. One is the good cause extensions of time that I've already mentioned. In addition, the bill increases the time for the panel to issue a panel determination. This is very beneficial in the process for two main reasons. It provides the review panel the ability to ask for additional information to determine whether it should refer the complaint or perhaps there isn't sufficient evidence and they can dismiss it. It also allows time for that review panel to direct what's called a deferral agreement. A deferral agreement is an agreement between the subject and the executive director, and it basically defers the charges under certain conditions, and on compliance with those conditions, the complaint is dismissed. The additional tools for the deferral agreement is AB 65 provides for additional terms that could be added into the deferral agreement: ethics training, public apologies, public admonishments, and conditions on future conduct. Now, it should be noted that that deferral agreement, like I indicated, is a contract between the executive director and the subject, and it is approved by the review panel. If the subject doesn't want to be subject to the conditions, then the case can move forward as the review panel determines in its panel determination to the commission for a full adjudicatory hearing. Once there is a referral by the review panel of a case to the commission, there are improvements in the bill to the adjudication of that complaint before the commission. Again, that written notice of charges is provided to the subject. And this is important because the review panel, like I said, may not find sufficient evidence to move the case along. And therefore, there may be only one of a number of charges that were originally alleged that will continue to the commission. Again, at this point in time, party status is confirmed. The executive director and the subject are the parties in the adjudicatory phase of proceedings. The executive director is represented by a position in the commission's offices that's referenced as associate counsel. Myself, I am commission counsel, and I will provide legal advice to the commission itself on how to conduct the hearing and any other compliance obligations on conducting adjudicatory hearings. Associate counsel will actually represent the executive director as a party and provide a presentation on whether or not there has been a violation of the ethics law by the subject in question. So the bill defines what those due process parameters are for legal representation for commission attorneys. For example, as commission counsel, I could not represent the executive director in those matters. That would be a due process issue. And all of these parameters comply with 233B on what is required to hold adjudicatory hearings. The one difference in the bill from the prior bill, Senate Bill 129, is that the commission determined it was appropriate to ask that the executive director be a licensed attorney. And the reason for this is very important because it's a very small staff at the commission. There are 6 staff members. And if the associate counsel has a conflict, for example, perhaps they have a relative who is actually the subject of the complaint, then that associate counsel cannot provide services on that complaint. That would be against appropriate ethics laws. So at that point in time, the executive director, if they are a licensed attorney, can act as conflict counsel and present the case to the commission. After the referral, the bill provides for a written scheduling order and discovery order, just like you would in a court proceeding have. And again, at this phase of proceedings, we have good cause extensions of time. Once the complaint is sued to the commission, there are some improvements to the complaint disposition process in the adjudicatory phase of proceedings. Now, if you recall the 3-member review panel, under current law, they are precluded from participation in the adjudicatory proceedings before the commission. AB 65 permits, just like a court will use another judge, a review panel member to mediate resolution or settlement in the adjudicatory phase. Now, this would only be with the consent of the parties, meaning the subject and the executive director, and that settlement negotiation or mediation would be separate from the adjudicatory process that's before the commission. In addition, the bill provides safe harbor protections to all recognized forms of preventative advice, so long as that advice is consistent with commission precedent and the requirements of the ethics law. That would include that informal advice by commission counsel and the executive director. It would include advice that is provided from legal counsel for the agency, or if they obtain an advisory opinion from the commission, that would be included. The bill also provides the commission additional time to prepare the final written opinion after it holds the adjudicatory hearing. Commission's processes in this phase of proceeding, unless there is a waiver, are very short. You have to take it from the notice of complaint, basically, to a hearing within 60 days. And that includes discovery, written motions, perhaps depositions, subpoenas. So it's very fast. So if there is no waiver, the hearing will be within the 60 days, and the bill allows the commission another 30 days to actually prepare its written findings of facts and conclusions of law as are required for these types of hearings. Next, I'm going to turn to just highlights of the amendments to the Ethics Code of Conduct. This is set forth in NRS 281A-400. And there's really three major areas. The top two that are referenced on the slide both pertain to NRS 281A-400 subsection 7. That section basically defines what a misuse of government property is by a public officer or a public employee. But if there is a misuse of government property, it may be excused if there is a policy established by the agency that within the defined parameters of the statute. The current law does not require that written policy be established in writing. AB 65 does that. And what this does is it prevents ad hoc or changes in policies or creation of policies to excuse conduct when the agency doesn't have that as part of their policy to all employees. In addition, if there is a waiver, if there is a limited use exception, one of the requirements is that limited use does not create an appearance of impropriety. So now the bill will add a definition of what is an appearance of impropriety to NRS 281A-400 subsection 7. In doing so, that language is consistent with US Supreme Court case law and Nevada Supreme Court case law. The other two additions to the Code of Conduct would be a violation of the ethics law to interfere with the commission's witnesses or investigation. And there's an addition of the unconscionable use of an official public position. Now, it's noted that this is a very high level standard, and it does not capture any conduct within the course and scope of official duties, negligence, or bias. The bill also makes a couple amendments to the disclosure and abstention requirements set forth in NRS 281A-420. Under 281A-420 subsection 1, public officers and employees are required to disclose certain matters like gift or loan, whether they have a significant pecuniary interest in the matter that they're working on, whether they have in a private capacity to another person that would be affected by the public matter they're working on. And also the fourth disclosure requirement is if they have provided compensated advice or representation for a person in the last year before an agency, and that matter relates to the public matter they're considering, then they would have to disclose it. And it is that fourth area, the compensated prior representation or counseling in the last year, that Assembly Bill 65 creates an amendment to. What that does, it still requires disclosure, but what it adds, that section before wasn't taken through into the abstention analysis. And now, just like the other three disclosure requirements, the disclosure of prior representation in the last year also will have an abstention analysis to make sure that the matter is reviewed to determine whether abstention would be required based upon the facts. Now, I put in the slide, so just to clarify that under the ethics law, abstention would be required when the facts present a clear case that the public officer's participation would be materially affected by the conflict under the application of the reasonable person standard. AB 65 also makes a few changes to the one-year cooling off provisions that are set forth in NRS 281A 550 subsection 3 and 281 550 subsection 5. Now, subsection 3 only applies to executive branch public officers and public employees, and it relates to hiring of public employees and public officers by the regulated business or industry. And there's a factor test in determining whether or not the prohibition of cooling off period of 1 year would apply. What this does, and this was actually requested in Senate Bill 129, is the bill raises the level relating to public employees to a management level. Currently, the law has anyone above a clerical level. So this would really raise this up to higher level public employees in the agency. Under the other cooling off provision, NRS 281A 550 subsection 5, that provision applies to vendor contracts. And currently, the requirement is that if the vendor contract is over $25,000 was awarded in the last year, and your position had the ability to influence or actually influence the contract board, then the cooling off would apply to you. What this bill does is it adds another factor to it. It indicates that those public officers who materially implemented or administered the contract also would be subject to the cooling off. Many times there are high-level management people that will have direct contract oversight and management of that contract and are working close together with that vendor contractor. And so this would also capture them in the cooling off requirements. The bill makes just a slight few provisions for our acknowledgement forms. What an acknowledgement form is that form that appointed and elected public officers must file with the Nevada Commission on Ethics on stated deadlines. And what it does is they file and they confirm that they have read and understand the ethics law. AB 65, the change that it makes in this regard is there's a list of public officers that is already provided to the Nevada Secretary of State as to who the public officer and public employees are from a given agency. What this section of the bill is the Ethics Commission would also like to be provided a copy of that from the various agencies so that we could just assure there's compliance with the ethics law. We would send out notices that perhaps we haven't received your your acknowledgement form. Currently, at this point in time, the ethics law does not have any fines or penalties for late filing on that. In addition, you will find a couple supplementary slides at the end of the presentation, and they just assist you in reviewing the changes in the bill, and they just are some background information that I'm going to leave it to the committee to review. I'm not going to go over them in particular. And one other matter I wanted to cover before we go into questions is I wanted to let the committee that we have circulated AB 65 and we've received a little bit of feedback from the locals on two provisions. One is section 8.2, and that's the duty for public officers and employees to cooperate with the commission in their investigation. public attorneys raised a concern that when they are representing subjects of the ethics complaints, that they would have that duty to cooperate in the investigation. The commission has provided the commission's chair and vice chair and myself delegated authority in a public meeting to process amendments to the Assembly Bill 65, and we don't have any objection to this minor amendment, and we will follow up with LCB staff and committee staff. In addition, section 27.3 is a subpoena for personal records. The concern is whether the personal records would become public documents if they were considered as evidence in a public adjudicatory hearing before the commission. Although these records would be part of the investigative file and have those protections, we have no objection to establishing a process by regulation so that either a stipulation or a motion to request sealing of records could be made by the parties, which regulation would provide the appropriate mechanism for personnel and other confidentiality records to be submitted under seal at the adjudicatory hearing. And with that, Madam Chair, I'll be happy to answer any questions you may have.
Great, thank you so much. Actually, so committee members, if you have a question, please IM me so that you can be recognized. I do have the first question we have up is from Vice Chair Housekeeping.
Thank you, Chair Miller. And I just want to start with one quick question and then maybe let other committee members jump in and then come back if there's time allowable. But I have concerns regarding section 22, and that's just from the start, because I know we had this conversation last session as well as to there's no limitations, and section 22 is what requires the executive director to be an attorney who is licensed to practice law in the state. And I know we had discussions about it in 2019 as well, but my concern here is that there's nothing preventing you from hiring an attorney who is licensed in the state, if that's the will of the commission to hire an executive director who is an attorney. But by requiring it in statute that it be an attorney, you are limiting or possibly disqualifying any other potential candidates who might be qualified individuals for this job. So if it is the will of the commission when needing to fill the position to look for an attorney, you can, but at least you're not prevented from hiring another qualified individual to fill that role if they aren't an attorney. And so I don't think we should be limiting the position to an attorney. Can you guys kind of just explain? I know this was brought in 2019, this section, and we had the conversation. So what was the thought process in bringing it back?
Thank you, Vice Chair Housekeeping, for the question. Through the chair to you in response.
Please go directly.
Oh, thank you very much.
Directly.
There are a couple of reasons that the commission decided to bring this back, and it is the one difference from Senate Bill 129 that was brought back. And that is because we're such a small agency and our time deadlines are so tight that to have somebody else come in and really understand the process of the ethics law, how to put it forward to the commission, takes training. So at that point in time, that's one reason it's a training issue. Another reason is that most of the public officers and public employees are under the authority of the commission. So even the Attorney General's office could be under our authority for an ethics law complaint, although they could act as conflict counsel. And the other provision is in law currently, the commission is able to hire outside counsel. And one of the biggest concerns was that the costs associated with that, especially given the state's budget and things like that. So we've always tried to limit the costs of conflict counsel. And yes, you are correct, Vice Chair Housekeeping, that yes, the commission can go ahead and advertise and include that as a preferred qualification.
Thank you, Madam Chair. Just a follow-up statement.
Yes, please.
Perfect. And Ms. Chase, you made my point there. Yeah, you guys could always advertise as a preferred qualification, but just not limit the opportunity to someone who might be a qualified individual, but then not be considered because they are not an attorney. But if it is the commission's desire to hire an attorney, there's nothing prohibiting them from doing so. Thank you, Madam Chair.
Thank you. We have a question from Assemblyman Lovett.
Thank you, Madam Chair. My question is more broad. I just wondered what prompted the need for the revisions to the current law. Has this been an ongoing thing where you were trying to make these revisions and just maybe didn't get them in previous sessions, or was there a situation that prompted these changes?
Thank you, Assemblyman Levitt, for the question. In response to you, in 2017, the commission will go through that made changes to the ethics law. And we have been monitoring those changes. And that's why we came back in 2019 with some revisions to our processes. In addition, the COVID-19 pandemic has really exacerbated our lack of ability to provide good cause extensions. And so it has just been, as we have been processing these cases, we've noticed that there could be additional clarity and protection of whistleblowers, number one, because, unfortunately, if it's a small agency and they can figure out from the materials that we're required to now provide who that person is, their confidentiality is compromised. We've just seen some issues, and that's why we decided to come back with this bill. And it's pretty much a procedural bill for the most part.
Thank you so much. I appreciate that. Thank you, Madam Chair.
You're welcome, Assemblyman. Assemblywoman Torres.
Thank you, Chair, and thank you for your presentation on this bill. Throughout the legislation, as I was reading, I noticed that in several places throughout the legislation, including Section 43, Section 44, Section 45, and I'm sure a number of other locations, there's an extension on the amount of time and the ability for the director to waive the time requirement completely, which almost makes it makes me a little uneasy, because it almost seems that the director would then be able to just extend that time almost indefinitely. So if you could just talk a little bit about the intention for doing that, the reason why that's necessary, and whether or not the commission has been able to function with the time requirements currently, because if that's the case, and I'm not sure that I see a reason for the ability to waive those extensions.
Thank you, Assemblywoman Torres, for the question. In response to your question, there are a couple reasons on the time requirements. If you look at the times that the commission has to process the different phases, and I'll highlight it with the adjudicatory phase, because you really only have 60 days to go through an enormous amount of materials. We had some cases where we had to subpoena records, and those records we couldn't even get within 60 days. And we were lucky enough to get waivers from the subject. But if the subject doesn't want to waive, we're stuck with the timelines that are set forth in the statute. And then, unfortunately, we haven't had to dismiss a case yet, but our resources are then redirected to that case. So what that has a trickle effect of is that other cases where there is a waiver may get delayed. So for the orderly processing of the case and the time they came in is a big factor, because if you have to delay an older case for a new case coming in, you could lose witnesses, you could lose evidence, and you could lose testimony. So that was one of the major reasons for really allowing the commission to navigate its extension issues. If the commission grants an extension time, a dedicated time will be provided, and it will be based upon the good cause standard that's set forth in the bill. In addition, the executive director right now currently can extend times for to respond to an ethics complaint in the investigative phase. But other than that, the other phases are up to the commission to determine whether an extension time is proper. And currently, they have no ability to extend the time unless the subject agrees to it. I might add to that, if during the COVID pandemic, if we had a staff issue, let's say, for example, we had an exposure in our office and we only have 6 people and our timelines can't be extended, it would create hardship in processing.
follow up if I may, Chair.
Yes, please.
Thank you. And I just feel like this gives the director an extreme amount of power to be able to weight that without having that conversation with the subject at hand. So I just feel like that this might be the other extreme and give a little bit too much flexibility to the office. And I would urge the commission to look at other ways that they could achieve that without this amount of this power.
Thank you, Assemblywoman. Do we have any additional questions from committee members? Okay, we will return back to Vice Chair Housekeeping.
Okay, thank you. I just wanted to make sure. And then just a couple, maybe one more question. Let me get back to where I was. I lost my section. If we could just jump to page 33 of the bill, it's section 32 sub 11, and this is just more for clarification for me, but you're removing the word willful, so willful refusal to execute and file the acknowledgement required by this section, and then you replace it with refuses, so I'm assuming it's the same thing, but so someone who willfully refuses, I can see how they would be in violation of the chapter, but what if someone just accidentally, didn't execute or file their acknowledgement? Why did you remove the word willful? Make it so that it was a purposefully done action.
Thank you very much for the question, Vice Chair Howdy. In response to your question, the willful was removed because the commission itself, if someone doesn't file an ethics acknowledgement form, they've already provided the executive director authority send out a notice saying, please file the form. And that's one reason why we're hoping to have those lists of public officers, so we can secure compliance rather than, have ethics complaints on whether you filed an acknowledgement form. In addition, willful was removed from the bill because there was confusion that they thought it was a purposeful, but if you have a continued negligence, you just don't do it. It may not be willful, but you're busy, you're not thinking about it. So either the form is filed or it's not, and the commission will basically indicate, please file the form at the list of public officers. And I don't recall in my 6 years with the commission that the commission has ever fined somebody for not filing the form, although they do have authority to.
And just one last question, Chair.
Yes.
Thank you. And then when it comes to section 27 on page 21, section 27 sub 3, where it says, except as otherwise provided in the subsection, upon the request of the executive director, they can subpoena, and then during the course of any investigation, and it goes on to list what they can subpoena. It says, any deemed by law to be confidential. What does that mean? Does that mean they can subpoena like attorney-client privileges or doctor-patient privileges, where it says information or records deemed by law to be confidential? Does that mean we're giving you the authority to be able to break those privileges?
Thank you, Vice Chair Howdy, for the question. In response to your question, no, it's just the opposite. If there's a confidentiality privilege in state law, this provision would not override that.
Okay, perfect. Thank you, Chair.
Thank you, Vice Chair. Any additional questions? Okay, seeing no additional questions, then we will open it up for testimony in support of Assembly Bill 65. Broadcasting, please allow those in support to get into queue. And while you are doing that, I'd like to remind everyone listening that if you are providing testimony, please make sure to state your first and last name clearly for the record, and your testimony will be, you will have 2 minutes for your testimony. So broadcasting, whenever you're ready.
This is Michael. Thank you, Chair. To testify in support, pardon me, which bill are we on?
Assembly Bill 65?
65. Sorry, I had them all written down and lost track there.
No problem.
Thank you. To testify in support of AB 65, please press *9 now to take your place in the queue. Caller with the last 3 digits, 232, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, this is Dave Daslich, Director of Government Affairs with the Las Vegas Chamber of Commerce. We're just testifying in support of AB 65 today. Robust and simplified ethics code for all public employees and elected officials we feel is vital to the operations of Nevada government and public trust in them. We think that this bill is a good step in streamlining these processes and ensuring that every claim is given sufficient consideration. So we would urge your support. Thank you.
To testify in support of AB 65, please press *9 now to take your place in the queue. Chair, at this time, there are no more callers in line for support on AB 65.
Okay, thank you. Can we queue up those who are in opposition?
Yes.
Thank you.
To testify in opposition of AB 65, please press *9 now to take your place in the queue. Caller with the last 3 digits, 120, please slowly state and spell your name for the record. Caller with the last 3 digits, 120, please press *6 to unmute.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman. Very, very rarely in the 2+ sessions that I've been on the front lines do I change my mind based on the presentation, but for many of the reasons outlined during Q&A, I will be happy to work with the presenters and committee on a midpoint. And with that, Madam Chair, thank you, and I yield.
To take the place in the queue in opposition of AB 65, please press *9 now. Chair, at this time, that is all the callers we have in opposition of AB 65.
Okay, thank you. Can we check and queue up to see if we have anyone in neutral?
To testify neutrally on AB 65, please press *9 now to take your place in the queue. Chair, the line is open and working. However, we don't have anybody to testify neutrally on AB 65.
Okay, well, thank you. And with that, I will close the hearing on Assembly Bill 65. Next up, we have an agenda item, Assembly Bill, let me back up. Thank you so much to the Ethics Commission for presenting the bill today. Thank you for that. I would be remiss without saying that, so thank you.
Thank you, Chair.
Now I will officially close the hearing on that again. I'd like to open the hearing on Assembly Bill 129 by Assemblyman Roberts. This measure revises the thresholds for political action committees to open and maintain a separate account and on the reporting contributions and expenditures. So Assemblyman, when you're ready.
All right, thank you, Madam Chair, and thank you, members of the committee. Good afternoon. I'm Assemblyman Tom Roberts from Assembly District 13 in Southern Nevada. Today, I'm going to present Assembly Bill 129. I'll first start with a little story on why I came to the realization that to pass this bill, or at least attempt to pass this bill. I'll go over the technical changes to the bill, and then I'll open up for questions if that pleases you, Madam Chair. So with that, so some of you know, or may be aware, or maybe you don't know, but I spent 34 years in law enforcement, to include a little over 24 years with LVMPD in Southern Nevada. During my last few years, I was the assistant sheriff over the Law Enforcement Operations and Support Group. Part of my responsibilities was overseeing all the criminal investigations at Metro. Some of those investigations were into political corruption and involve abuse and misuse of campaign funds. Many of those funds involved and resulted in the prosecution of members of this body as well as other bodies in our state. The commonality in these cases was that minor indiscretions with campaign funds led to major criminal activity. A lack of visibility and transparency of campaign funds allowed for these minor indiscretions and abuses to occur. There were several changes to individual campaigns accounts in 2017 and 2019 by this legislative body that gave more visibility to the public and lowered the donation thresholds, expenses, and cash on hand reporting. I believe that these changes were a move in the right direction and it lessened the likelihood of abuses. I also noted that a majority of these changes passed with unanimous support or almost unanimous support in both sessions. During the last election cycle, I received several campaign materials, just like most of you did, and some were actually from political action committees. I make it a habit of looking up these PACs to see more information about these groups. Very many of these groups fully disclose contributions as expenses at any dollar amount. In actuality, it's actually more commonplace than not, even when it's not required. I also saw that some PACs that reported tens of thousands of dollars in donations and expenses gave little or no information listed on the form. Basically, there were funds spent in several tens of thousands of dollars and donations, and there was zero visibility on it, giving voters and donors no ability to see what their money is going to. So as a result of that, I did a little research, and I found that candidates for federal offices in federal PACs itemize all contributions and expenditures over $200. Both federal candidates and federal PACs are required to report cash on hand. Candidates for non-federal office in state of Nevada are required to report contributions and expenditures over $100. They also must report cash on hand. This threshold was lower in 2017, as I mentioned before. AB 129 decreases the thresholds for PAC reporting to lower the reporting contributions and expenses amounts to $100 and requires PACs to report cash on hand. This brings Nevada PACs in line with the candidates with what candidates already do. It also more closely mirrors the federal reporting requirements. With that said, the purpose of this bill was not intended to shed light on low dollar donors, but more focused on where the money is being spent, reporting cash on hand so that voters have the visibility on where their money is going and reduce opportunities for misuse and abuse. Based on some feedback that I've received from citizens and advocacy groups, I am open to leaving the donation threshold at $1,000 and with a later amendment if it pleases the committee and the members. Now I'll go over the mechanics of the bill. Under existing provisions of Nevada Revised Statute, a PAC is generally defined as a group that solicits or receives contributions and makes or intends to make contributions or expenditures designed to affect the outcome of an election. While PACs are required to open and maintain a separate account for contributions and to report contributions that exceed a certain amount, these requirements are inconsistent with requirements with PACs, with individual candidates. Section 4 of the bill revises current law to require PACs to open and maintain a separate account to deposit contributions of $100 or more no later than a week after receiving them. Sections 2, 3, 6, and 8 require a PAC to report contributions and expenditures in excess of $100 during reporting period if the contribution received is in excess of $100. 2, if a contributor's total exceeds $100 and expenditure exceeds $100, or the total cumulative expenditure exceeds $100. In addition, the measure increases PAC's reporting requirements during a reported period to include all contributions received during that period for $100 or less, the balance of the account of the ending date reporting period, and the total of all expenditures that are $100 or less made during the reporting period. Section 5, 7, and 9 through 12 make conforming changes to reflect the new requirements. Section 13 specifies that these new requirements only apply to reports on contributions and expenditures filed after the PAC on January 15, 2022. So with those remarks, Madam Chair and committee members, this concludes my presentation. As I said before, I'm open to leaving the contributing levels the same. This bill was never intended to shed light on donors, but more oversight and transparency on the operations of these PACs. And so with that, I'll take questions, Madam Chair.
Thank you, Assemblyman. Do we have any questions from committee members? Any questions? Assemblywoman Dickman.
Thank you so much, Madam Chair. I don't know what it is with my chat, but it's disabled for some reason. Anyway, thank you, Assemblyman Roberts. I really appreciate what you said about being open to changing the donor portion of it, because we've seen in, especially with controversial types of ballot initiatives and even some recalls, where people have experienced retribution for being donors, and the small donors are just, you know, individual ordinary citizens for the most part. And I think that's the problem that a lot of people had, a lot of concerns people had with this bill. So thank you so much for being open to changing that.
Through you, Madam Chair, to Assemblywoman Dickman. You know, so when I first drafted the bill, just to bring it in line, and when I did research, it was actually very common that most PACs and political action committee, you know, and other groups in the state already report all contributions. So I didn't see it as a huge issue when I drafted the bill, but until got some feedback from some groups, you know, I felt that there could be some movement there, and that was not the intent to expose minor donations or donors. So thank you.
Thank you. Thank you so much. And thank you, Madam Chair.
You're welcome. Thank you, Assemblywoman. Any additional questions? Well, seeing no additional questions from members, we will move into accepting testimony. So broadcasting again, while you get everyone queued up, we'll start with those who would like to testify in support of Assembly Bill 129. And again, for those testifying, you will have up to 2 minutes to express your support. Please make sure you state your first and last name clearly for the record.
To testify in support of Bill AB 129, please press star 9 now to take your place in the queue. To testify in support of AB 129, please press star 9 now to take your place in the queue. Chair, this is Michael from Broadcast. We don't appear to have anyone on the line in support of AB 129.
Okay. Do we have anyone in opposition?
To testify in opposition of AB 129, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 859, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. This is Janine Hansen, the state chairman of the Independent American Party. I did send my testimony in. However, I would like to broaden what I've said there. One of the most important things is the experience in California on an issue on the ballot for marriage between a man and a woman. They published everyone's addresses on a Google map, and they were subject to slashed tires, vandalism at their homes, threats, and intimidation. This is real, and this can happen. When I ran for state senate as an independent American several years ago, I was told repeatedly that people would only give me $100 because they didn't want their name to show up on the Secretary of State's website because the Republican Party or some other powers that be wouldn't like it and would come after them. These laws suppress political free speech, which is our most important free speech. Years ago, when I participated in the Axe the Tax petition campaign, we had a gentleman at Tahoe that donated money. He had a distribution business. When his name showed up with the Secretary of State's website, the casinos who were against that canceled all of his contracts, and he ultimately lost his business. These are real things that happen to real people, and we've got to be very careful to protect donors, especially small donors, so that they are not subject to harassment, threats, intimidation. This is part of the cancel culture, and if we are to protect free speech, we need to protect those who are giving money to causes, to ballot questions, and to other events. I think this is very important that we have, if not to defeat the bill entirely, which I am against the entire bill, that we should at least cut out the part that Assemblyman Roberts talked about with regards to donors. So I hope you recognize the fact that free speech is money, and without money, there is no free speech. And those that suffer the most are those that have the least power in the political system by all of these rules. Of course, our founders never envisioned all of these rules to have to report money for political campaigns, and they believed in anonymous free speech. What cures the problem of free speech
Ms. Hansen,
from one person?
Your time is up. Ms. Hansen, your time is up. Okay, thank you. And I understand that you had mentioned that you had already submitted in writing as well. Can we go to our next caller, please?
Caller with the last 3 digits, 319. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. My name is Melissa Clement, Nevada Right to Life, MELISSACLEMENT. I'm testifying today in opposition to AB 110. Campaign and finance reform is problematic as it has the very real effect of impacting the First Amendment freedom of speech. In today's cancel culture, it is not by any means a stretch of the imagination to foresee that opponents of viewpoints could use the donation disclosures as a means to identify, target, and intimidate individuals who have donated to causes. In fact, this has happened. We saw it in California. We've seen it elsewhere. This has a chilling effect on speech, pure and simple. $100 is a tremendously low threshold and would most definitely be found unconstitutional. As such, I truly appreciate Assemblyman Roberts' willingness to amend the bill, and I hope that the committee considers this amendment. And if not, I urge you to vote against AB 129. I'm sorry, at the beginning I said 110. I meant 129. Thanks a lot.
Caller with the last 3 digits, 112. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
This is Bruce Parks with Battleborn Patriots. As you may recognize the name as the group that instituted the last recall against the occupier of the governor's mansion. I would like for you to know that in the interest of transparency, our first report that we had to send to the Secretary of State's office, we included every donation we had received. It became readily apparent that was a mistake. Our donors were targeted. The next time we had to report, I reported only donations that were in excess of $1,000. There weren't many. I would like for you to strongly consider doing away with this bill. It does nothing to further transparency in campaign or political action committees. It opens up Nevadans for retribution for simply being involved in the political process, a fundamental right guaranteed by our Constitution. That you would consider the threshold of $100 is reprehensible, and I don't understand it. Please, if you're not going to amend this, then do away with it. Thank you for your time.
Chair, this is Michael from Broadcast. There are no more callers in the queue for opposition on AB 129.
Do we have anyone for neutral?
To testify in neutral on Bill AB 129, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers in neutral on AB 129 at this time.
Okay. With that, thank you, Assemblyman Roberts, for bringing forth this bill. And I will go ahead and close the hearing on Assembly Bill 129. With that, we will move on to our next agenda item, which is a work session for Assembly Bill 110. We actually have an amendment on this bill, and Director Erdos is with us online, who she will walk us through the amendment. So Director Erdos, when you're ready.
Thank you, Madam Chair.
Madam Chair, I hate to interrupt, but if
Yes.
I don't want to put LCB in a position because they're not allowed to advocate. Just don't want to put them in an awkward position of laying it out. So if I could just lay out, with your permission, the overview of the intent of the amendment, and then have Director Erdos walk through the actual language so that she's not advocating for legislation, if that's okay.
Absolutely.
Thank you again. For the record, Jason Fryer, Assembly District 8. This measure was amended to address what appeared to be some confusion at the bill hearing regarding the preamble, which was laying out what got us to today, but was not part of the actual legislation that would go into statute. And so this amendment takes that out, really just for the purpose of avoiding that confusion, that this is specific to COVID or the pandemic. And allows us to focus on the actual bill. The bill as intended and the amendment that Ms. Erdos is going to walk through is intended to provide clarification that this is not expanding the types of people who need to register, but simply take into account that participating virtually is a new normal, and in adapting and modernizing, this may continue to be beyond the pandemic, the way that some people participate and some people lobby. And so the intention is to make sure that folks that lobby without coming into the building, but still lobby on behalf of another person or another entity, are required to report same as if they had to enter the building. And so I was glad to discuss this with my colleagues throughout the assembly that had concerns. I certainly, and I provided language to those that had some concerns with the expectation that this resolved those and made clear what the intention of the bill was. And so with that, Madam Chair, I'll stop talking and let Director Erdos walk through the actual language. The other thing that I'll point out, I don't want to leave out, is that it adds that this applies both in a regular and also a special session. And so with that, I would invite Director Erdos to walk through the language of the amendment.
Thank you for that clarification.
Thank you. As the speaker indicated, this proposed amendment removes existing section 1 of the bill, which was that intent section, and instead adds a new paragraph H to subsection 2 of NRS 218-080 in section 2 of the bill, which is intended to accomplish the same goal in sort of a, I would say, more substantive manner. That is by adding an exception to subsection 1 so that it's clear that a person whose only lobbying activity is infrequent and irregular and is not required to register as a lobbyist unless the person engages in a pattern of conduct that amounts to lobbying over the longer term. This proposed amendment also adds a new section 2.3 to the bill to amend NRS 218H200. And this amendment's added to clarify that a person is only required to register as a lobbyist when they act as a lobbyist. It was currently already in one of the provisions of the existing law, but as we look through the section, it just seemed like it would be good to make it clear here that really the requirement to register as a lobbyist only applies to during a regular or special session of the Nevada Legislature. And then once you are registered as a lobbyist for one of those sessions, then you must continue to comply with the provisions of 218H regarding lobbyists throughout until the next session of the legislature. There's a similar provision adding a new section, section 2.7. It's the same language that we're adding again to make it clear that the requirement to register as a lobbyist, which is actually stated in NRS 218H 180 already in existing language, just to make it consistent so that it's clear when you're reading all of this that that you know that when you have lobbying activities during a regular or special session, you need to register, and then after that, after you've registered, you are considered a lobbyist for all the provisions of the regulatory provisions of the chapter until the next legislative session. The only other changes in this proposed amendment are in section 3, which is the transitory provision, and we just wanted to make it clear that that transitory provision only relates to this particular session of the legislature while this bill is out there and being changed. And then the Legislative Council's Digest is made to be consistent with all of those changes. And I'm happy to answer any questions that you might have. Thanks.
Thank you, Director. Okay, members, do we have any questions?
There are no questions. I'd like to make a motion to amend and do pass.
Okay, I will accept that. Do we have a second?
This is Assemblywoman Monroe Moreno. I will second the motion.
Okay, thank you. We have a amend and do pass by Vice Chair Hardigy, and we have a second by Assemblywoman Danielle Monroe Moreno. Are there any comments or questions on the motion? Assemblywoman Dickman?
Just a quick comment. I just wanted to thank Mr. Speaker and Ms. Erdos for working with us to address some of the concerns we had about the potential of this bill's effects down the road. And really appreciate them working to make this easier for us to vote for. Thank you.
Thank you, Assemblywoman. I believe we have a question or comment by Assemblyman Matthews.
Yes,
Thank you, Madam Chair. I just wanted to echo what Assemblywoman Dickman said and express appreciation. Director Erdos, Speaker Frierson, all the others who helped address some of those concerns. Of course, transparency is something we all should support, something I certainly support. And I know from the beginning that clearly was the intent of this bill. And I think that's great. And again, just wanted to express my gratefulness for all the work that went into getting this bill to where I believe is a very, very good place right now. So thank you very much.
Thank you, Assemblyman. And Assemblyman Levitt.
Thank you, Madam Chair. Without sounding like a broken record, I'm going to sound like a broken record. I just wanted to show my appreciation to Speaker Frierson and Director Erdos for their work on this and just for the sake of clarification for our sake and truly converting the language to express the true intent of the bill, which is transparency, which I very much appreciate. So I'll be a yes on this bill. Thank you.
Thank you, Assemblyman. Any other questions or comments before we proceed? Okay, so with that, I would like to ask our committee secretary to take a roll call vote. Again, in the online virtual, it's hard to decipher between votes and sounds, plural sounds. So if we could do a roll call vote, please.
Assemblywoman Dickman,
Yes.
Assemblyman Frierson,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Howdegi,
Yes.
Assemblyman Levitt,
Yes.
Assemblyman Matthews,
Yes.
Assemblyman MacArthur,
Yes.
Assemblywoman Monroe Moreno,
Yes.
Assemblywoman Thomas,
Yes.
Assemblywoman Torres,
Yes.
Chair Miller.
Yeah. And with that, the motion carries. I will take the floor statement for this bill. I will assign it to myself on this one. With that, we will move on to the next agenda item, the last one being public comment. So again, while broadcasting, please prepare and get everyone queued up for those who'd like to make public comment. Just reminding everyone that the public comment should pertain to those that are in the purview under this committee. You will have 2 minutes per person. And with that, we will wait for broadcasting to tell us when our first person is ready.
Chair, this is Michael with Broadcast. The public comment line is open and working, and right now we have no callers at this time. Would you like us to hold on a while just to see if anybody calls in?
We'll just hold on another moment or so to give people a chance. I know sometimes it quickly moves from committee business to the time to call in, so.
Okay.
Just in case someone's dialing. Does there appear to be anyone who has dialed in yet?
Chair, there are still no callers at this time.
Okay, thank you for that. Well, with that, seeing no callers for public comment, this will conclude the meeting for the day. We do not, I'm sure everyone has noticed on the agenda, we do not have a meeting scheduled for this Thursday. So you will see when the next meeting is scheduled, the agenda will be posted. And with that, the meeting is adjourned. Thank you, everyone.